Good evening, ladies and gentlemen. For years, Section 124A has been a bone of contention. And this section of the Indian Penal Code or the Sedition law aimed to quell incitement, hatred and disaffection towards the state. But for years now, we've witnessed rampant misuse by ruling parties to target their political opponents through this law. And very few convictions in these cases where the law has been invoked. Ladies and gentlemen, it was in July 2021 when I had told you here on the Newshour that the centre is open to bringing in regulations to prevent the misuse of this law, and in the next 2 months we will know what those regulations and what those changes in this law will be. While the government stand is being welcomed by politicians across the board, the Congress was quick to claim credit for this decision. Listen in to the law minister of the country and the opposition who claims this is vindication of the allegation they've been making against the Modi government for years now.
We respect the court, we respect the independence of the court, but there are things which is called Lakshman Rekha. All the organs of the state must respect each other and also to practice our respect in letter and spirit. Whatever we say, whatever we do.
कांग्रेस 2019 में ये कानून खत्म करना चाहती थी। आज देश की सुप्रीम कोर्ट ने इस पर पाबंदी लगाकर साबित कर दिया कि हमारा रास्ता सही है, लोगों की आवाज उठती रहेगी, यही जन आंदोलन की परिपाटी है। जय हिंद।
The plea of the government, Modi government, that it will review the cases is specious because it has been misusing grossly this sedition law to harass all dissent. Since 2014, since this BJP government came into office, 326 people were arrested under the sedition law and only 6 of them were convicted by the courts.
While the opposition has been busy calling the Modi government names, it has conveniently ignored some facts that I want to highlight tonight. Rahul Gandhi tweeted today and said, speaking the truth is patriotism and not treason. But what he forgets that 3 people were held for destabilizing the Jharkhand government based on Congress's complaint. So, Mr. Rahul Gandhi, would you just look into your own backyard when you make allegations against the government at the centre? Another claim by the Congress was that voice of dissent can no longer be suppressed. But they seem to have conveniently forgotten that the Gehlot government invoked the law against his party MLAs 2 years ago when they spoke out against him, because these MLAs happened to be opposing him and supporting his dissident colleague Sachin Pilot. He said it was an attempt to destabilize the state government by his own MLAs from his own parties. That's not misuse of the law. The Congress even forgets about cases like those that it has filed against BJP leader in Punjab when the Congress captain Amrinder Singh was chief minister for criticizing the state's COVID preparedness. And the biggest irony of this entire political fight is of the Maharashtra Congress chief claiming that the centre was misusing the law but went to court only after the Aghadi government, in which he is an ally, filed a sedition case against Navneet Rana and her husband. So the legitimate question on the Newshour tonight: righteous in court, unjust outside. Is that the Congress party's stand? That's the debate on the other side.
You're watching the Newshour at 9. Debate number 1 on Times Now, Super Prime Time.
And joining me tonight, Shehzad Poonawala, national spokesperson of the BJP, my friend and senior advocate Aryama Sundaram, Sanjay Hegde, senior advocate of the Supreme Court, Sanjay Gupta, leader of the Shiv Sena. But my first question goes to Advocate Kapil Madan, political analyst. Mr. Kapil Madan, a little rich coming in from the Congress party to claim all the victory because the Supreme Court has stayed the law after the government has said that it is willing to look at changes in it and rework the entire law. Why is the Congress celebrating? Have you not misused the sedition law? And that it's a fact that for 75 years that this country has been an independent country. Your party ruled the longest, maybe 55 years, and never thought that the sedition law should be thrown out of the window. But today you want to uncork the champagne and claim credit for what's happened in the Supreme Court. Advocate Kapil Madan.
That suggests that after 2014, there has been an indiscriminate use of sedition sections, and that is 124A. Now, let me respond to what the government has done, though the government is now trying to take credit of it. If you look at the history of this litigation before the Supreme Court, the government has not filed the affidavits in time. They have been dragging their feet, and now when they know what is the fate of this petition, they have very, very clearly, in order to save themselves from the embarrassment, they have filed this recent affidavit wherein they have requested the court not to spend time. However, the court was conscious of the fact that what the government is trying to do, and therefore the Honorable Supreme Court posted the matter next day and asked the government to, let the court know how do they intend to deal with the pending cases of 124A, and it is a step in the right direction. And I think we should all praise the Honorable Supreme Court. And I would just say that there is never a wrong time to do a right thing.
Okay. So the right time arrived in the Modi government and the right step was taken by the Modi government, but the Congress is celebrating nevertheless. Shehzad Punawala?
Look, today the Supreme Court of India has, after the Government of India took a principled stand that there should be a re-examination and a review of this colonial legacy law, has put a stay on the application of this law. And this is a law, we must have some context. Today this Congress's 400 BC on 124A will not do. The fact of the matter is that the Congress party was the one that applied this law for 9,000 people in 2012. Now, if you take the tally of the cases that have been filed from 2014 to 2022, it might not be more than 550 cases. So the Congress party has no locus standi to talk about it. On the one hand, they said in 2019 manifesto that we want to do away with the law, and then lo and behold, it was applied not just on political rivals like Navneet Rana in Maharashtra, it was applied on journalists who had questioned the government, it was even applied on people who are in their own party, as you have rightly pointed out, in Rajasthan, because they were dissenting from Ashok Gehlot. This is a Congress party which has gone to the extent of imposing emergency. This is the Congress party that has banned several books and movies in the course of its existence. In 1951, it was Jawaharlal Nehru who had brought in the first amendment to the constitutional right to free speech, and that opened the gateway for actually constitutional validation of sedition law in 1962 in the Kedarnath case. Minus that first exception that was drawn to the first constitutional amendment that was made by Jawaharlal Nehru, sedition law would never have stood the test of constitutional validity. Apart from that, in 1973, it was Indira Gandhi's government which actually made sedition cognizable for the first time in the history of India, and arrest without warrant was made possible only under Indira Gandhi's time. Mr. Nehru in 1951, I remember, had said that sedition law is useless, it is obnoxious, it should be done away with completely, immediately. But for 35 to 40 years, the Gandhi family members were in the position of power out of the 60 years that they ruled this country. Why did they not do away with it? And today they sit on a high horse and they preach about freedom of speech and expression while trampling upon the freedom of speech and expression of the likes of Navneet Rana only for reciting the Hanuman Chalisa.
Well, absolutely. And let me ask, Sanjay Gupta ji, अब क्या होगा? अब हनुमान चालीसा सड़क पर अगर पड़ी जाएगी तो शिवसेना की सरकार किस किस को अंदर करेगी? क्या होगा? पॉलिटिकल प्लान किया आपका चला गया, सुप्रीम कोर्ट ने बड़ी ज्यादती की आपके साथ।
देखिए नाविका जी, जब कोई कानून होगा और जब उस तरह की कोई प्रतिक्रिया होगी तो उसका इस्तेमाल भी किया जाएगा। अब जहां पर अपोजिशन में बीजेपी की सरकार है, जहां पर कांग्रेस की सरकार है,
you used it on नवनीत राणा for हनुमान चालीसा। वैसे आपको खास जरूरत नहीं है, पर क्योंकि था तो इस्तेमाल कर लेना चाहिए। It's like a suit hanging in the cupboard. You might as well wear it out for a party.
नवनीत को राणा पर इसलिए हनुमान चालीसा ना पढ़ने के लिए या पढ़ने के लिए केस रजिस्टर नहीं हुआ है। उन्होंने जो एक संवैधानिक परिसर, मुख्यमंत्री आवास में ज़बरदस्ती घुस के सिक्योरिटी को तोड़ करके एक ऐलान कर दिया कि मैं इस दिन जाऊंगी, इस टाइम जाऊंगी और ये करूंगी। तो मुख्यमंत्री आवास एक संवैधानिक परिसर होता है और वहाँ पर सिक्योरिटी भी होती है, वहाँ पर हनुमान चालीसा पढ़ा जा सकता है, मगर इजाज़त तो ली जाएगी, बात तो की जाएगी कि भाई 9 बजे करना है या 10 बजे करना है, 11 बजे करना है। ऐसी थोड़ी कोई ऐलान कर देगा
क्या
कि मैं तो इस
कानून
वक्त
व्यवस्था तोड़ दी थी? क्या ऐलान किया था ना?
ऐलान कर देना,
लोग लेकर
ऐलान कर देना भी कानून अपराध है।
ऐलान कर देना इस सेडिशन,
ऐलान कर देना मतलब आप क्या चाहते हैं कि क्राइम का करने के लिए कोई बात कहे और करने के बाद उस पर संज्ञान लिया जाए, करने के बाद एक्शन लिया जाए।
और कोई सेक्शन नहीं था आपके पास सिवाय सेडिशन लॉ के जिससे आप उसे रोक सकते थे?
कैन आई आस्क अ क्वेश्चन ऑफ संजय गुप्ता? संजय गुप्ता जी, सेडिशन का कानून, संजय गुप्ता जी,
इसको जैसा सही लगेगा वैसा ही किया जाएगा कानून अनुसार। अगर कोई
नहीं जैसा सही लगेगा वैसा नहीं किया जाता। कानून जैसा सही लगता है वैसा नहीं, कानून की एक प्रक्रिया होती है।
हनुमान चालीसा पढ़ने का एक तरीका होता है। हनुमान चालीसा अपने घर पढ़ी जाती है,
नमाज तो
मंदिर में पढ़ी जाती है या किसी समारोह में पढ़ा जाता है,
सड़कों पर पढ़ी जा सकती है।
आज तक मैंने अपनी लाइफ में नहीं सुना किसी ने ये कहा हो कि मैं तो किसी घर के आगे जाकर के हनुमान चालीसा पढ़ूंगी। अगर हनुमान चालीसा पढ़ने की सच्ची भावना होती,
आपने एक बात कहा कि आप शिवसेना की सरकार की नुमाइंदगी करते हैं। आपने कहा कि ऐलान किया तो सेडिशन लगा दिया। आप ये कह रहे हैं कि महाराष्ट्र की सरकार ने केवल ऐलान पर सेडिशन लगाया। ये आपको पता है ये कानून है, ऐलान पे सेडिशन लगता है। ये आप कह रहे हो कि कोई किसी ने कोई अनाउंसमेंट किया तो उस पर सेडिशन लग गया, तो केवल अनाउंसमेंट पर सेडिशन
जाकर के ऐसे करूंगी या करूंगा, तो इसमें तो ऐसे होता है।
चलिए वकील बैठे हैं, वो बताएंगे आपको कि ऐलान पर सेडिशन होता है।
ऑलराइट, संजय गुप्ता जी, आप कह रहे हैं कानून व्यवस्था बनाने के लिए for law and order the only provision available was sedition law. I want to ask Aryama Sundaram. Mr. Aryama Sundaram, do you think any party can come out smelling of roses as far as the use or rather the misuse of the sedition law, section 124A of the IPC is concerned?
Certainly not. If you ask me, Navika, the one universal factor is the misuse of the sedition law. You know, it's been on our statute books. It's a colonial act. It's been on our statute books in the form as brought in the colonial era. The fact of the matter is there's nothing wrong with having a law against sedition. But one has to understand what is sedition. It basically tantamounts almost to treason against the country, against India. It's not an outcry against a given government or of the day or a criticism of the government or its policies. It is really something which affects the sovereignty, security and integrity of the country itself. It's a law which has to be kept in very strict straitjackets. Now, we've had this law from pre-independence days, and it's continued in the statute books, been used and, or I'd say misused, misinterpreted ever since independence. It has been repeatedly used, and I cannot see any political party which has been at the helm for so many years of any of this time to try to distance themselves from it. On the contrary, they encouraged it, they allowed it, and they allowed it to come in. Finally, I'm glad to say it's come to a stage where the apex court has taken it on and has said, look, this really has to be relooked at, because this is a provision which, as it stands, is something which is capable of tremendous misinterpretation, misuse, or even because of the looseness of the terms used. And don't forget, it was brought in the colonial days when they wanted to protect king and emperor and wanted to protect the English rule over India. So it is very loosely framed in order to see that the oppressor, which was the colonial power ruling, could take care of having any criticism from the oppressed. But to continue it after independence in that same form naturally led to the kind of misuse which you have seen. And that has been done universally by political parties over years since independence. And so there's no political party which can even try to distance itself from it. And finally, it's when the apex court has taken it on and talked about it, I'm glad to see that there was a proactive step from the state itself, the government of the day itself, which turns around and says, all right, we will relook at it, because I think it's something we need to relook at. And since the government itself has come forward and itself accepts that 124A in its present form is something which severely has to be relooked at, the court naturally, as a consequence, has said, good, all right, you want to relook at it, we will give you the right to do so, since you're the executive, since the legislature can relook at it. But in the meantime, do not use a law which you yourself feel is not a law which can be given effect to in its present state. So I think today's Supreme Court order was a bold order, a strong order, but an order in consequence, and is a natural corollary to the government itself coming forward and saying, we want to relook at this law.
Let me get to the brass tacks of the politics and the political equations in this country. Can the opposition today claim credit for the rollback of the law as it stood and claim vindication?
Certainly not. Certainly not. On the contrary, the opposition of the day has been ruling this country for 4 times as long as any other party has. And for that period of time, it never struck that same opposition to turn around and say, look here, this law needs to be relooked at. This law is a colonial law. We should not use the law. On the contrary, for 60 years, a party has ruled, and that party kept the section in the statute books and has kept it going and has used it. So I don't think any party can take credit over this. Certainly not.
Well, Sanjay Hegde, do you agree that this was a change waiting to be made, and today when it is being made, there is reason to believe that even the opposition has egg on its face, given the recent times in which this law has been misused by state governments. Example number 1, of course, is Maharashtra, the Navneet Rana case, Rajasthan, where Rajasthan police comes knocking on the doors of journalists every now and then, wanting to pick up journalists. Do you think these are, in recent times, unsavory applications or cases that have been made out by the opposition, and today the Supreme Court rightly has put an end to all of this?
Well, the Supreme Court has rightly put an end to all kinds of misuse. Whoever has been in government and in a position to misuse it, and if there is no particular provision under which you can get someone, so you invoke sedition. You have this government which invoked it against Kapil Kumar, for instance. That also will go. You have the Mamata Banerjee government which invoked it against a Jadavpur university professor. This, to my mind, to use a Hindi phrase, it was like bandar ke haath mein ustra. Any government which had it could use it arbitrarily. Now, for once, the Supreme Court has said, boss, this has gone on far too long. We in 1962, in a 5-judge bench, had upheld it, subject to guidelines. Those guidelines nobody follows. In any event, the Constitution, the living Constitution, has moved far from those days. It is the government of the day has volunteered and said that, look, we are going to take a relook. You may take a relook, but what do we do about all the things that have happened so far? So, A, let us not have further extensions, no fresh cases. B, those cases that are already been filed, let them apply for bail if they are in custody.
You use the term bandar ke haath mein ustra. I do not agree with that term, because बंदर किसको कहा आपने मुझे पता नहीं, और इस बात पर if there is a defamation case, then the channel takes no responsibility, and since you are a senior advocate, you will fight your own case, if it is filed, because sedition law may be undergoing changes and may have been stayed for the moment, but defamation laws could apply. I completely disassociate myself and the channel from that. But Sanjay Hegde.
Let me complete. See, it could not only be defamation. Defamation is what you are now apprehending. It could have been sedition, and I could have been in trouble both with the central government as well as the Mamata government, as well as with the Maharashtra government and 100 other governments. So that is the real question. Do you need something which is so overbroad, applied arbitrarily, that some things you let slide, some things you go full all guns blazing. Who should make that decision? Therefore, it is best that we get rid of this section. And as I told you earlier also, it doesn't take very long. One ordinance, gone. By the time we keep on debating, I really think that this section has no place. There are 100 circumstances and 100 other sections which can be applied. If you want to get someone, there is USPA, there are so many other things.
In which case, if you subtract out of the 75 years that this country has been independent, 8 years that Narendra Modi has been here and his government, 67 years where the other governments could have done it and failed to do it.
You had 7 years. You had 7 years of Vajpayee. Okay. You had about 5 years of the Janta government.
60 years.
12 years. No, 12 years plus. Let's not quibble about facts in that sense. How many years?
Is this quibbling about facts, or is this giving a long road and only pointing fingers at the present dispensation, Shehzad Punawat?
See, Mr. Hegde has used a Hindi idiom. I want to use another one, and that idiom is "Saw chuhe khakar Congress haj ko chali." This is the Congress party which has constantly applied and brought in laws like MISA and TADA. It was the one which also brought in the UAPA law. Today it opposes that UAPA law. This is the party that for 40 years, and the first family members were the Prime Minister in these 32 to 40 years when they were at the helm of affairs. Forget the other Congress governments led by Narasimha Rao. They were at the helm of affairs themselves. They did not listen to their own Nehruji and remove this law. So the onus lies on them as well. And also, after declaring in their manifesto that they wanted to do away with the law, then to go ahead and impose this law, even when there was not the basic guideline was not followed, which is the essential element of violence taking place, that was not taking place, and still it was applied in Rajasthan, it was applied in Maharashtra. That was a complete U-turn that they did on their own stand. And therefore, the right idiom would be "Saw chuhe khakar." Now Congress party haj ko chali, and it's trying to portray that it is the biggest champion of free speech. By the way, the Congress party...
The idiom actually is 900 चूहे खा के आप तो 100 में निपटा रहे हो 900 चूहे खा के बिल्ली हज को चली
बिल्कुल
Kapil Madan respond to that.
Yes, so let me respond to Shehzad here. So he made a remark about that 100 चूहे या 900 चूहे. तो मैं जरा अगर आप रिवर्स ऑर्डर में चूहों की गिनती करोगे तो आपको सबसे पहले मिलेगी दिशा रवि. We all know what they did with दिशा रवि. उससे पहले थोड़ा सा और चलोगे तो आपको मिलेंगे सिद्दीकी कपान. We know all, what they did to Siddiqui Kapan. So perhaps my friend here, Shehzad, he's a learned man, he's a talented man. He has used a very right idiom, and in the present context, it fits to what the BJP is actually doing, and it basically exposes the diabolical nature of the party, the hypocrisy. I mean, as our own honorable Prime Minister has once said, hypocrisy की कोई कोई सीमा होती है. So it's an example of that.
Hypocrisy.
No, can you tell me whether Navneet Rana, because she wanted to chant Hanuman Chalisa, the law of sedition could be applied on her? Mr. Madan, let's talk like lawyers on this panel. You don't need to interrupt me. Mr. Madan, if your argument is strong, you can hear me out. Mr. Madan, can you please ask him to hear me out? I'll make my point, you answer after that. Mr. Madan, I'm asking, yeah, I'll answer about Disha Ravi also. I'll answer about Disha Ravi also.
But give me an answer on Disha Ravi.
I'm answering about Disha Ravi also.
Please go ahead.
Yes, I am answering. Now, please tell me, first of all, merely announcing that you will chant Hanuman Chalisa, does it attract sedition, yes or no?
Disha Ravi.
Disha Ravi case.
Hanuman Chalisa.
No, one second. In the Disha Ravi case.
ये क्या बात हुई?
In the Disha Ravi case. By the way, in the Disha Ravi case, even though it was not upheld by the court, now please listen to the argument. In the Disha Ravi case, I am talking about Disha Ravi also, and I am talking about Hanuman Chalisa case also. Please listen to both.
We will discuss.
Yes, we will discuss both. Now, please tell me, at least in the Disha Ravi case, there was a case of violence that had been made out by the authorities. But in the Hanuman Chalisa case, she had not even chanted the Hanuman Chalisa. Where was the chanting of the Hanuman Chalisa that took place? And does sedition get attracted by mere chanting or mere announcement of chanting of Hanuman Chalisa? This is the difference. That is the problem. You have completely abused the sedition law. You applied it on 9,000 people protesting at Kudankulam. You applied it on Asim Trivedi, and today you are trying to be holier than thou. Please look at the list of books, list of films that you banned. And Congress party, the one that imposed emergency, is talking about free speech.
Absolutely, and let me take that question to Aryama Sundaram. Mr. Aryama Sundaram, in 1951, Section 91(2) was added with reasonable restrictions to freedom of speech. Now, reasonable restrictions then led on to what all in this country, you know. And in 1974, just at the cusp of emergency being declared in this country, the sedition law was made a cognizable offense. Is the Congress in any position tonight to begin to say and point fingers at other political parties when their own record, their own history sheet is so checkered on the misuse of the sedition law?
Certainly not. Like I said earlier, it little behoves one of these parties to point a finger at another. But that's politicking. All they're doing is politicking. And when you're in the opposition, anything the ruling government does, you try to point a finger to, quite forgetting that when you were in power, you did that and much more, and much worse in many ways. We had an emergency, we had various other issues. Now, like you say, sedition law was not only maintained, retained, but in fact made even more stringent in the earlier years. As you yourself pointed out, it was made a cognizable offense. Now, these are things which the Congress party cannot wash its hands away from. It's very convenient when sitting with the opposition, in the opposition, that you can criticize anything that the government is doing, whereas the government has just kept on the statute books what you yourself have kept on the statute books all along and made even more stringent. So I don't think it lies in the hands of any one party to turn around and blame another for what has happened. All that I can say is that by the very nature of the law and the very nature of its fluidity in its interpretation, the very loose expressions used there, it has been misused time and again ever since independence. Nothing new. It has been misused time and again, and it's about time that this was taken in hand. The Supreme Court, fortunately, has come down on it with a very, very strict eye. And fortunately, again, the government has been reactive and has said, yes, we will also look at it, and we also feel it needs to be relooked at. And the court has said, and very boldly has said, look, we are glad you are going to relook at it. Please do relook at it, and in the meantime, do not give effect to the section. Well, I think it's a very happy state of affairs we're in today. And I'm saying it's a happier state of affairs that we have been in than since 1950, whoever the government was in power. And none of the governments which have ever been in power at that time have any right to raise a hand in criticism. But on the contrary, if there's one finger pointing at their neighbor, there should be four pointing back at them, since they've ruled 4 times as long as others.
Well, Gupta ji, शिव सेना सरकार जिसने हनुमान चालीसा पर सेडिशन लॉ का इस्तेमाल किया था, आज कम से कम नेशनल टेलीविजन पे इतना तो कह दें कि गलती हुई, शायद सही नहीं था डिसीजन।
नहीं, आप गलत तरीके से बात को कह रही हैं। और शिवसेना ने की सरकार ने हनुमान चालीसा पर कोई सेडिशन नहीं लगाया था। हनुमान चालीसा वो
के ऐलान पर लगा दिया था,
जिस तरह से
हनुमान चालीसा के ऐलान पे लगा दिया था।
देखिए, ऐलान पे नहीं लगाया था, ना तो हनुमान चालीसा के ऐलान पे था, ना हनुमान चालीसा पे था। वो तो इस बात पे था कि मुख्यमंत्री आवास पर बिना टाइम लिए सिक्योरिटी को तोड़ते हुए अपने आप जाकर के जो उन्होंने ऐलान किया उस पर था। अगर उन्होंने हनुमान चालीसा पढ़नी है तो उनका स्वागत है। अगर बीजेपी ने जिस तरह की नाव पे उनको बिठा रखा है, मुझे लगता है कि उन्हें देखने की जरूरत है कि वो नाव
जी के घर पर गई थी क्या? गई थी?
नहीं, इस बात का ऐलान कर देना कि मैं जाकर के ये काम करूंगी, इस वक्त करूंगी, तो मुख्यमंत्री आवास एक संवैधानिक परिसर है। इस तरह के ऐलान कर देने से ही अपने आप क्राइम हो जाता है।
चलिए,
ऐसा नहीं है कि वो जाति तो ही क्राइम होता है। ऐलान कर देना कि मैं ये काम करूंगी,
सेडिशन लॉ लगाएंगे, कानून में और कोई प्रावधान नहीं है।
तो सिक्योरिटी फोर्सेस को तोड़ करके जाना है।
अगर आप सिर्फ
तो देखिए, आप मुख्यमंत्री आवास को क्या समझते हैं? आप क्या मुख्यमंत्री आवास ऐसा है कि कहीं भी कोई भी जा सकता है, जाकर के कहने लग जाएगा कि मैं ये काम करके आऊंगा और करके आऊंगी?
लॉ एंड ऑर्डर नहीं रहता। आपको सिर्फ सेक्शन 124A मिला लगाने के लिए। सवाल ये,
उसके अलावा उन्होंने बहुत सी अभद्र भाषा का इस्तेमाल किया। इससे पहले कि मुख्यमंत्री आवास से मुख्यमंत्री आवास से कोई प्रतिक्रिया आती, वो उस पर कुछ संज्ञान लेते, उसका जवाब देते, उससे पहले उन्होंने बहुत कुछ बोलना शुरू कर दिया।
सवाल इस बात का है, सवाल इस बात का है,
जिस तरह की भाषा का उन्होंने इस्तेमाल किया वो आपने दिखाया नहीं।
आप मुझे सिर्फ इस बात का जवाब दे दीजिए, मुख्यमंत्री है, उनकी रिस्पेक्ट होनी चाहिए, उनकी अवमानना नहीं होनी चाहिए, सही बात है, लेकिन लॉ में और प्रावधान है कि नहीं, नंबर 1 सवाल। और नंबर 2 सवाल जो मैं पूछना चाहती हूं कि आज तक जो दूसरों को हिटलर बुलाते आए हैं, क्या वो खुद हिटलर नहीं बन गए?
किस तरह से, मतलब आप क्या चाहती हैं कि वो जो नवनीत कौर राणा संसद में खड़ी होकर के आज तक प्रभु श्री राम का नाम लेने वालों का विरोध करती रही, आज ऐसा कौन सा उनको इंजेक्शन लगा, कौन सा उनका अंदर ऐसी अंतरात्मा उनकी जागी कि हनुमान चालीसा करेगी, वो भी इस तरीके से जिससे होती नहीं है।
आपकी भी तो अंतरात्मा जागी है ना 3 साल पहले तक।
अंतरात्मा वो जगी नहीं है, वो बीजेपी ने कोई चश्मा पढ़ाया है उनको, ये शहजाद पुणे वाला जी ने।
कमाल है, आप दूसरों से सवाल पूछते हैं, आप अपनी अंतरात्मा से पूछ लीजिए, ऐसा क्या बदल गया कि बाल ठाकरे साहब क्या क्या कहते थे कांग्रेस के बारे में, आज आप उनके साथ बैठे हुए हैं, आपकी अपनी अंतरात्मा से जो पूछ लीजिए, वही सवाल का जवाब नवनीत राणा का भी होगा।
देखिए, जिन भी मुद्दों पर बाला साहब थे, आज भी शिवसेना उन्हीं मुद्दों पर है। आज भी शिवसेना प्रभु श्री राम के मंदिर के साथ खड़ी है, आज भी शिवसेना धारा 370 के साथ खड़ी है, आज भी सीए के साथ खड़ी है। नंबर के आधार पर सरकार बनाने से पार्टियों की अपनी विचारधारा नहीं बदलती। संजय को बीजेपी ना जाने कितनी पॉलिटिकल पार्टियों से 90 से ही
के लिए
नंबर के आधार पर सरकार बनाती रही है, तो क्या इससे बीजेपी ने अपनी विचारधारा को त्यागा? लेकिन सिर्फ शिवसेना एक ऐसी पॉलिटिकल पार्टी है जिसने 30 साल किसी के साथ कोई गठबंधन नहीं किया, इसलिए शिवसेना के बारे में की बात सोची जाती है।
संजय गुप्ता, दुर्भाग्यपूर्ण बात है कि आपकी तो अंतरात्मा मर चुकी है। जो आज वीर सावरकर जी को गालियां देते, केरला में उन पर प्रतिबंध लगाते कांग्रेस पार्टी के लोग, आज उनके साथ आप बैठे हुए। सर मैं देखिए सर, मैं किसी के बीच में नहीं बोलता हूं। संजय गुप्ता, आपने लगातार बोला, मैं किसी के बीच में नहीं बोलता हूं। नाविका, ऑडियंस
संजय गुप्ता जी सत्ता भोगने के लिए जो हनुमान को त्याग सकते हैं, वो तो बीजेपी को त्याग ही सकते हैं। आप शहजाद की भी बात सुन ले।
देखिए,
देश में डेमोक्रेसी तो चली रही है।
आत्मा इस प्रकार से मर चुकी है कि जिन्होंने राम जी के अस्तित्व पर सवाल उठाए, जिन्होंने राम मंदिर को 70 वर्ष तक लटकाया, अटकाया, भटकाया, जिन्होंने राम सेतु को तोड़ने की साजिशें रची, जिन्होंने वीर सावरकर को अपमानित किया, आज उनके साथ सत्ता का भोग ले रहे हैं और आज कह रहे हैं टीपू सुल्तान महान है, परंतु सावरकर जी को गालियां दे रहे हैं। तो ये तो इनकी अंतरात्मा मर चुकी है पूरी तरह से। पर ये सवाल नहीं है, आज सवाल ये है, देखिए एक सेकंड प्लीज संजय गुप्ता जी, आप अपने समय पर भी बोलते हो, आप दूसरों के समय पर भी बोलते हो, ऐसे थोड़ी डिबेट होती है भाई।
मुद्दे पर
प्लीज आप दूसरों की बातें भी सुन लिया करो। देखिए, आज सवाल सिर्फ इतना है कि आज
अगर लेंगे आपसे, किस दिन क्लास ले लेते हैं आपसे।
पहले तो मुख्यमंत्री महाराष्ट्र या मुख्यमंत्री भारत नहीं है। मुख्यमंत्री के खिलाफ प्रदर्शन करना इस देश में कोई अलोकतांत्रिक या गैर संवैधानिक या गैर कानूनी नहीं बन चुका है। तो क्या आपका तो इतिहास, शिवसेना का पूरा इतिहास प्रधानमंत्री और कई मुख्यमंत्रियों के खिलाफ हिंसक आंदोलन से पैदा हुआ है। यह शिवसेना का इतिहास है और आज वो शिवसेना केवल एक हनुमान चालीसा पढ़ने के ऐलान पर सेडिशन केस लगाती है और जायज ठहराती है। और मैं आपसे पूछता हूं कि एक पीएफआई के मतीन शेखानी ने बीच सड़कों पर कहा कि छेड़ेंगे तो छोड़ेंगे नहीं, उस पर सेडिशन केस नहीं लगा। सार्वजनिक जगहों पर नमाज अता की जाती है, उस पर सेडिशन तो छोड़िए, उन पर तो 144 वायलेट करने का केस नहीं लगता है। लाउड स्पीकर किसी एक मजहब का बचता जाता है, परंतु आप हनुमान चालीसा पर केस लगा देते हैं। ये आपके दौरे मापदंड है। आपका तो सियासी धर्मांतरण हो चुका है, आपका कुछ नहीं हो सकेगा। सेडिशन तो अलग मामला है, आप तो 420 ही कर रहे हैं। ये तो 124 का मामला है, आप 420 लगाते हैं सब पे।
संजय हेगड़े, द रीसेंट केस इज दैट ऑफ this particular one which is under discussion, and I want to ask you today, isn't this a wake up call to those governments as well, to show them the mirror on how intolerant they themselves have been at a time when they've been accusing the central government of intolerance?
Well, there are some figures out here that there were about 405 cases of sedition listed, filed over the past decade or so, of which about 140 were for insults to the Prime Minister and some 120 for the Chief Minister of Uttar Pradesh. Ultimately, you see, whoever is in power will use it to crush dissent. So if there is a government in power in a state, it will use it against its dissidents. A government at the center is more likely to use it against its dissidents. Question as citizens that we have to ask is, should we cede such power to our governments? Who do governments think they are? Are they public servants, or are they king emperors with a majesty which cannot be breached, where their wounded vanity can be addressed by threatening somebody with a life imprisonment? So this is an overbroad section, whether it was there in a colonial time or whether it is there in independent India. This is not a section that sits well with a democratic polity. This is an opportunity also for the central government. If you want to think that you are a great Democrat, please prove it. Remove it from the statute book.
So Agni Pariksha required only for this government, not for earlier governments. Aryama Sundaram, is that a fair basis to judge the present situation and the present debate?
Navika, that is, there's no fairness in politics. That's pure and simple politics.
Sanjay Hegde is not a politician.
Today is in power.
His glasses may wear,
but Sanjay Hegde, I
have
don't know
certain lenses of certain colors, but he's definitely not a politician.
I'm not talking about Sanjay Hegde being a politician, but let me say that what he has said is something which is very indicative of politics. A party which itself has subscribed to the law, has made the law even more stringent, is now finding itself in the happy position of an opposition which can blame another party for not doing something with the law. And I go back to the first question you asked. Is it open for any one party to blame the other? Is it open to a party which has been at the helm for years and years and this law has continued to point a finger at the present government? My answer is no. It's not in their hands to point a finger. But the point is the section has to go in the form it presently is. If you want to keep sedition, then retain it to what it should be, which is really something akin to treason, affecting the sovereignty, integrity, security of the country, of India. And the law has to be changed, and I am glad that when the Supreme Court has so strongly and boldly taken it on, the government has been responsive enough to say, yes, we also agree that the law has to change. And today's order of the Supreme Court has really been, look, I'm glad you also agree. Well then, everyone stays their hands and does not give effect to this law until the government comes forward.
Absolutely, and we are on the cusp of change, ladies and gentlemen, and this change is for the better. Anybody who begins to celebrate that this change has happened because of them should really look within to see how many times have they misused this law. Especially the opposition parties that are celebrating and saying, I told you so. On the other hand, citizens of India, and especially my colleagues, people of my tribe, certainly have reason to celebrate, because now truth will not have any restrictions. And truth is what we stand for. Thank you very much to my panelists for joining me on debate number 1.